Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. Last night, the Philadelphia Phillies won a baseball game against the Boston Red Sox, entirely due to the principles of fairness. It was the 10th inning, and a batter for the Phillies was up, and it was determined by the umpire, the judge over the baseball game, that the catcher had interfered with the batter in the box. And that's what won the game for the Phillies. In Idaho versus Kohberger, you have seen and read the 14th Amendment to the United States Constitution cited many, many times. And that also has to do with fairness. The 14th Amendment Due Process Clause mandates that when a state government, like Idaho, is seeking to take someone's life, liberty, or property from him or her, three things must be present. Number one, notice. Two, an opportunity to be heard. And three, impartiality, going to the fairness of the proceedings. In May of 2025, Judge Stephen J. Hippler entered two document hold orders where the court found that it appeared the court's non-dissemination order had been violated due to a leak the court believed came from law enforcement or a member of the prosecution team, which caused sensitive documents under seal from the public to somehow make their way to the media. And the court in those orders explained how this situation made seating an impartial jury required by the 14th Amendment to be more difficult. As I give my opinion on whether or not Mr. Kohberger could appeal, should appeal, I don't know, but what I do give my opinion on is it just didn't seem fair to me that he would be required to go to trial without knowing if possibly one of the witnesses, his attorney, was cross-examining, had any role in the leak of those documents, because he does have a right under that same Constitution of the United States to confront witnesses. In using another real-world example, if I could, my son loves chocolate cake, and he was very excited to learn that I was going to bake a chocolate cake for him. And I did bake a cake. When he came home and he went into the kitchen, he saw not a chocolate cake, but a vanilla cake there, because I did not put chocolate into the mix with the eggs and butter and flour and sugar and other things that you do that makes a chocolate cake, all of the elements, all of the ingredients. In a very rudimentary way, look at the elements or ingredients of what it is that must be present for first-degree unaliving to have been brought against Mr. Kohberger. And in looking and considering what the prosecutor said after Mr. Kohberger pled guilty, as he did back on July 2nd, 2025, he seemed to state that intent was missing. Intent is a necessary element of first-degree unaliving. Without intent, there cannot be a charge of first-degree unaliving. It may be something else, such as second-degree, which doesn't require intent, but it's certainly not first-degree. And I wonder if it was fair to charge him, Mr. Kohberger, with 4 first-degree unaliving counts when the prosecutor seemed to confirm that at least for some of those counts, he knew that intent wasn't present. Again, I give my opinions. speculation under the First Amendment to the United States Constitution. Thank you.